Welcome back. Hope everyone had found a place for lunch. I have great news. Some books have now been successfully given away. More to come at the end of the day. So we are ready to move on to our second NCR panel to start us off for the afternoon. And it's my pleasure and honor to introduce this panel. Now, last time I forgot the moderator. Sorry, Jake. This time, Justice Presser is your moderator. I think she needs no further introduction. Thank you, Justice Presser, for moderating this panel. On the unique challenges in relation to NCR, we'll be talking about procedural matters and involuntary NCR. Also on your panel, Justice Daniel Moore of the Court of Justice. And many of you will have known that Justice Moore, as Justice Presser, was a prominent member of the defense bar who engaged in a lot of litigation in mental disorder matters, including at the Court of Appeal. And we've got Stephanie Penney with us, who's a psychologist at CAMH. Psychologists play an integral role in mental disorder and criminal justice, and we don't hear often enough, in my view, from them. Jolene Hansell is criminal defense counsel in Ottawa. Jolene's chapter in our book is about what happens when an accused person opposes the NCR verdict, but somehow still comes under the board's jurisdiction. And you can appeal the NCR all you want, but you're still under the review board. So it's a weird little situation. She's written a beautiful chapter about that. And last but not least, all the way on your right, my left, is Jennifer Chambers, the Executive Director of the Empowerment Council, who are systemic advocates for persons with mental health issues and who use drugs. And the Empowerment Council has done some of the most important litigation on behalf of vulnerable individuals living with mental health issues. And Jennifer is to be credited for engaging in that systemic work for the last number of decades. So this is a wonderful panel. Welcome, everyone.
Thank you very much, Anita. So we're going to start off. We're endeavoring to answer as many questions that were submitted by attendees as possible. And there were a lot of questions about involuntary NCR. So we're going to start there, and I'm going to ask Justice Moore to lead us off, the lay of the land and the law.
Okay, so by involuntary NCR, we mean when the Crown is seeking to have the accused person found not criminally responsible. If you were hoping for a discussion of automatism and sleepwalking and that sort of involuntariness, then you'll have to go somewhere else, unfortunately. I'm sorry to disappoint you. I would hope that the Crown would put the defendant on notice at the earliest possible stage that they're thinking of seeking an NCR finding, because that gives the defendant, and certainly prior to plea, oftentimes, well, not often, it certainly has happened that the defendant only learns after they've entered a plea of guilt to the offense that the Crown is seeking to have them found NCR. That I think would likely be grounds to strike the plea, since they weren't fully informed of all the consequences of it. But it does sometimes only come out when, for example, somebody might have pled guilty and there might have been live mental health issues. So you've ordered a Section 21 assessment just to see how their mental illness played a part in the offense, and also to assist in their rehabilitation. But during the course of that report preparation, it may have become some NCR possibilities might have been raised at that time. So it does sometimes happen that even though counsel didn't think it was going to come back NCR, there's some issues raised after plea. But turning to the more sort of traditional application, the Crown can only adduce evidence in support of an NCR finding after the accused has been found guilty of the offense. That's Swain from the Supreme Court of Canada. But that does not prevent the Crown from advising the accused of its intentions or taking other procedural steps, such as applying for an assessment order. An assessment order pursuant to Section 672.12 can be made at any stage of the proceedings. Can be done by the court on its own motion, although personally I've never done it prior to a finding of guilt. I suppose it could happen. If the Crown is applying, they must show reasonable grounds to doubt that the accused is criminally responsible on account of mental disorder. Where the Crown is raising the issue and applying for the assessment, there's no adverse inference that can be drawn from the refusal to cooperate with the assessment. So defense counsel will want to have some conversations about that with their clients. And of course, where the Crown is raising the issue, the burden of proof is on the Crown pursuant to Section 16 sub 3 of the Criminal Code. It's on the burden of proof that the person is not criminally responsible is on the person that's raising the issues, or the party that's raising the issue. Sorry. So and in the case of involuntary NCRs, it'd be the Crown.
Okay, Jolene, can you comment on professionalism issues from the perspective of defense counsel? How do you deal with involuntary NCR?
Well, so I mean, there are kind of two perspectives, and sometimes the involuntary NCR comes out of kind of a place where you've had a conversation with the Crown, or where it just appears on the synopsis, like this might be an NCR kind of live issue. And at kind of the earliest juncture, it's really important to have a conversation with your client about what it is that they want and what it is that has happened and how they want to go through this process, because the outcomes can be very different, right? When you're looking at something that's a first-degree murder scenario with a potential NCR, that's a very different scenario than when you're looking at mischief with a potential NCR, because that mischief might be worth almost nothing if it goes through mental health court. Ultimately, the charges could be withdrawn, right? That mischief might be worth 30 days, depending on the criminal record of that person. But in the ORB system, if there's a finding of NCR, then you can have significant knock-on consequences to that, right? So if the Crown's leading the NCR first and foremost, it's important that, and your client does not want an NCR finding, that the Crown is put to their burden of proof, right? And that you test that evidence and that you resist that finding, because if ultimately they're found guilty and ultimately there's an NCR finding, you still have a right of appeal on the actual conviction itself that will undo the NCR. So it's important that you explain those options to your client before going forward.
So moving on from involuntary NCR, but sort of picking up on some of what Jolene said, Jennifer, I'm wondering if you can comment on some of the considerations around whether to raise an NCR defense or not, benefits and risks, that sort of stuff.
I want to begin by thanking the people who are or have been in the forensic mental health system who've informed me on these matters so insightfully. So clearly the NCR can be the most just of findings in some cases, especially if the Supreme Court agrees with us on Barwani. But the result can be quite unjust. For index offenses that might have resulted in months, as Jolene mentioned, people can end up spending years in forensic detention, particularly if there's someone who doesn't play the game of deference within the system very well. It's a system in which compliance is often equated with mental health. And really, how many of us could live somewhere 24/7 and be unremittingly compliant and good-tempered for years on end? The forensic hospitals are typically physically nicer places to live, but being free is preferred by most people. So recommending NCR for anything other than what would be a very serious crime contains a risk that the client should be informed of so they can choose the outcome that they want. You can also spend just as long secluded in the mental health system as you might spend in segregation in the correctional system, with the addition that chemical restraints are added to your situation. You do have a chance of being released sooner, but it's a very slim chance. The chance is much greater that you're going to be held in detention longer. And believe me, the lawyer who told their client that this is going to be a few months in a nice hospital is hated around year 2. The forensic system can be more compassionate. It's not supposed to be punitive, but it can also be very capricious in what gets counted as a risk, which affects your liberty interests. For example, I knew someone who had told their doctor they knew how to perform magic tricks. This was then noted as a person believing that they were magic and that they're therefore psychotic. And in addition to this unfortunate interpretation of the person's behavior, it's extremely difficult to get corrections made to a record once something's erroneously put there, no matter how obvious the mistake might be, it tends to hang around the person's record forever. And of course, that record is the basis for their report that gets entered into their annual review board hearing, which is then the decision about whether they're released or not. And just finally on this topic, biases can also enter into how people are perceived in the mental health system. So anti-Black racism, Islamophobia, anti-indigeneity can enter into how people are treated with more force in the mental health system, just like it does in the correctional system.
Justice Moore, do you have anything to add with respect to considerations around whether to raise an NCR defense or not?
Yeah, I mean, obviously, it mostly depends on, or a large part of it's going to depend on what sort of jeopardy your client's facing in on the criminal side of things. But the other thing to remember is that mental health can change from day to day, week to week, and month to month. So even if you have a client who right now is relatively stable and compliant with their doctor, and they have a good relationship, and it looks like they're on their road to a fairly quick, disposition in the community and maybe a discharge in short order, that can change very quickly. They can have decompensation, they can get a lot sicker, and then all of a sudden something ends up having them in CAMH or other places for years or decades. So just keep that in mind. And the other thing in terms of the facts that sort of follow along, I think it is important to, even if you're going to be joining in an NCR finding, that you actually get it. Don't go with the police synopsis, which is almost always far worse looking than the actual facts, and make sure that your client is really agreeing that they did all these things, and try and rather than going with the synopsis, try and get together with the crowd. If you're going on a consent basis, try and get an agreed statement of facts that's a bit more friendly to your client.
Do either of you, Jolene or Stephanie, have anything you want to add on this subject?
Just piggybacking off what Jennifer said, we know actually through the research we've done at CAMH and other forensic hospitals in the province that the evolution, right, of the ORB and the NCR system has really changed over time. And I'm sure not surprising to a lot of you in this room that the really substantial widening of the net around the types of offenses and the types of mental health problems that we see compared to the Lieutenant Governor's NGRI system, right? And so, like Jennifer was saying, a proposed NCR for a first-degree murder charge is really what the system was reserved for, 30, 40 years ago. And then over time, we saw a real widening of these kind of beneficent NCRs and people with really any type of offense being eligible for that. So it kind of makes these issues all the more salient, I think.
Interesting. Okay, continuing on with looking at ethical and professional issues around NCR. Jolene, can you lead us off?
So when you're either pursuing as defense counsel an NCR defense, if it's going to be your defense and not on the consent of the Crown, or a Crown consent position, it's really important that you explain what the entire consequences of that decision are to your clients, and that they have a clear understanding. And depending on the client, it may require more than one conversation and multiple confirmations of the consequences of that NCR finding, right? And the biggest one being, even if it looks pretty clear cut, even if they look relatively stable at the moment you're getting that instruction, right? You're not guaranteeing the absolute discharge, right? You're putting the forensic system very much on the table, and the consequences of what that might be if you're detained in custody at a forensic system, and the fact that you have to wait for the ORB to discharge you, and you get, subject to the exceptions of early reviews and things like that. It's on a yearly basis that status is reviewed. And, I think someone can correct me, but I think kind of the average in total that someone spends in the system is on average somewhere around 7 years. It kind of depends on the offense, but you can spend quite a bit of time, right? going through the system and getting discharged. There are steps that you can take if you're going to pursue an NCR defense at the outset to help set you up better for that initial disposition hearing or even the second one, which are, if you've got a client that has insight, you can start participating in programming, getting into hospital treatment. Those are really challenging to do. The wait lists are really long. We've all had clients where they've, shown up at a hospital in crisis and it's not enough for a form to hold and they get discharged, and there's kind of this repeated cycle. But even just the act of them going to the hospital on their own volition over an extended period of time can be really helpful in showing that they have insight and what they will do when they recognize themselves to be decompensating. And so that can help kind of set your client up for success down the line. And if you're going to pursue an NCR defense and you have a client that's capable of those steps, then those can be conversations that you have in terms of trying to set them up for that absolute discharge, either right out of the get-go or, conditional and then becomes absolute, hopefully at the next ORB.
Let me ask you, following in relation to ethical issues for the defense lawyer, to what extent do you try to convince your client of what you think the correct way to proceed with the case is, and to what extent do you not do that?
So you can't convince your client one way or the other, right? Ultimately, it's their decision. What you can do is present them with the options that are available to them, right? Option number one is the Crown wants 30 days jail for this. At the end of, you've done however many days, let's say it's 0, you're going to serve 2/3 of that at 20 days. You're done, 2 years probation to follow. This is what it's going to look like, right? Probation can look like getting you in contact with a mental health worker, and we can get you supports in the community to deal with kind of maybe their underlying mental health issues, right? For option number 2, there's an NCR defense that's available to you based on what you're explaining to me. We'd have to get an assessment from a doctor and kind of how you take the steps to go through from there. My preference in scenarios where they're defense-led NCRs is a private NCR assessment where, in not all cases, they can be privately funded, and if legal aid's agreeing to fund those things, because then you as the defense counsel have control over that information and can make the next decision as to whether or not you want to lead the defense, right? Based on kind of the consequences of what's in that report. But ultimately, you have to explain, and sometimes more than once, all of the different options and what the potential consequences are on liberty in the long term to your client, and they have to be the one that decides.
Okay. Jennifer, do you want to add anything on the subject of the ethical professional issues?
Well, when you're within the system, people can experience get caught in the ethical dilemma of the fact that they want often to heal, perhaps from some abuse experiences they had, but their therapist is also their jailer. So if they actually go through the process necessary to do the healing that they need, it might involve some expression of emotion that's then going to get them equated as being at a higher risk. So for clients, it's also difficult decision-making. And the dilemma I can have as a non-legal advocate is that I may know a client's being treated unfairly, but I also know from the reports of many people who've gone through the system that if they go along, they're going to get out sooner. So I have to just explain that I know this isn't fair. If your priority, though, is to get released, it's probably better to just go along and pretend it's okay. However, it's up to the person. It also depends on how egregious the situation is that's happening.
Stephanie?
So I want to talk just a little bit about these NCR assessments, whether they're private or, through a hospital, and specifically when psychological testing is part of that assessment. So this is prior to any finding of NCR or guilt, and some of the ethical issues that can arise. So I think a lot of us are familiar with the dual role. So the doctor kind of as your jailer once you're in the ORB system. And I think psychologists also face a similar dual role. So almost always the psychological testing is voluntary. So it's a voluntary component of an NCR assessment. And I think it's also really important to be straightforward about that results of the testing can go either way, right? And similar to violence risk assessments, these can be kind of congruent with what the client might desire or not. And so when components of psychological testing include cognitive functioning, even assessment of malingering, or in other words, a potential to exaggerate or feign psychological symptoms, depending on the results of that assessment, you can imagine that the results could be in favor of an NCR or not. And so, all the more reason to be very kind of straightforward about how the results inform the legal issue of NCR and how they can inform that issue one way or the other.
So I think we want to move, do you have anything to say about ethical and professional issues?
Yeah, I think you really have to know your client, spend the time, get to know them. The better you know them, the better advocate you're going to be. You'll learn to pick up, oh, he's having a bad day today. We're going to adjourn this. This isn't a good day for him. But you only will learn to recognize those signs if you actually know your client and spend the time with him or her in order to get to know them. Just one other sort of side issue, there's a case from Justice Pomerantz called Veltman, VELTMAN, about getting your clients a privileged assessment pursuant to section 672.12. It used to be called a Bernardo order. I think the Veltman goes a fair bit farther than Justice Watt did in Bernardo. And it's basically you can get a state-funded assessment that will remain privileged unless and until you decide to actually lead it. So you can get that privileged assessment that without having, because normally it would be provided to the Crown and the court when it comes back, but according to Justice Pomerantz, anyway, you can get that without disclosing it.
Okay, let's move on to talk about process during consent NCRs. And Justice Moore, I'm going to ask you to lead off on that.
Okay. We really should have Erin Dan on this panel since she's done probably several dozen appeals of NCR consent findings that were later overturned by the Court of Appeal. So you've really got to watch out for I guess the sort of paternalism kind of issue. Everybody thinks this is what's best for the accused, but you got to start off with first, is the person actually guilty or not? Because if they have a defense to the charge, they should not be engaging in a consent NCR, because it's and even if they don't have a very good defense, if they are at least saying that they believe things that suggest to you that they're not willing to admit the essential elements of the offense, then you should be having a trial. You shouldn't be having you shouldn't be admitting to facts that your client doesn't agree with. You also need to, as I said before, be sort of constantly monitoring how they're doing the day of and the days leading up to it. If they're wavering or waffling in any way, stop it. Don't go ahead. Also, make sure like the facts that are agreed to on the consent NCR are going to be following your client for possibly many, many years to come. So make sure that you've crafted them, that make sure, and if you and the Crown disagree on some facts that might be a bit more aggravating or less aggravating or mitigating, then you can always have a Gardner hearing to, actually dispute those facts rather than just sticking with the police synopsis. Obviously, trial judges have a real duty as well to do a very thorough inquiry before you, it's not, I mean, you have to be careful with joint submission sentencings too, but this is way more important than that. You have to really dig down deep, and it's for guilty pleas, I usually let counsel do it on their own, but for a consent NCR, I'll let them start it off, but I'll also have some questions to make sure that the accused really knows what they're getting themselves into.
Anyone else want to chime in on consent NCRs?
I would just add that if you're doing a consent NCR, it also really matters what ultimately are the counts, right, that you're going to plead to. And there's a decision of the Court of Appeal called Alley. It's a 2019 decision. I can't remember who wrote it, but it deals with whether or not you can be a member of a terrorist group as a as a single individual. Can like one person be acting for the benefit of a terrorist organization, or do you need multiple people involved? And the issue ultimately, like why it was important, was because he's convicted and that follows him through the NCR process, right? Like that level of risk goes up a lot higher when it's assault cause bodily harm or assault with a weapon. And then when it's done for the benefit of, right? When you have that extra tag on it, can really increase the risk factor when you get to the ORB hearing and make it very difficult kind of for when you're asking for different liberties under even a detention order, or when you're looking for a conditional discharge or things like that. So even if, you know, the basic facts you're prepared to admit, right? Yes, there was an assault caused bodily harm. My client's given me those instructions. Be really careful about the other things that are attached to them and whether or not the Crown can prove all of those individual things, because those matter when you get to the ORB system, maybe even more so than they may have kind of in that initial moment.
Jennifer, anything to add on consent NCRs?
No, I found that very interesting.
Okay. Stephanie, let's move on. Do you have any other insights for us in relation to psychological testing?
Yeah, so two pieces actually. So in terms of what Jolene was saying around risk, you know, even if the NCR is kind of segmented and it's dealing with a particular capsule of offenses and not others, sometimes the risk assessment can be more comprehensive than that. And actually, in fact, as assessors of violence risk, we're encouraged to, you know, to do a comprehensive assessment. And so even if things aren't legal convictions, but the person is talking about different behaviors throughout their history, those will count and they can very much elevate risk. So that's another thing to keep in mind. And then in terms of the psych testing, what's often very difficult when psych testing is happening alongside a psychiatric assessment of criminal responsibility is, right, we know these assessments are kind of retroactive and we're trying to retrospectively construct somebody's not just mental health symptoms, but also the resulting incapacities. And often for very serious offenses, the time that has elapsed between when the actual index offense occurred and when the psychological assessment might be happening can be months, sometimes years. And so, especially if we're thinking of mental health disorders as dynamic and fluctuating, and someone's risk can be fluctuating as well, to have that as the task at hand to kind of do this retrospectively and construct somebody's mental status and psychological symptoms and potential of exaggerating or feigning those symptoms in a retroactive way can really sometimes layer complexity and sometimes like a lack of reliability of these assessments.
Okay. Jolene, do you have some thoughts as well about timing of assessments?
Yes. So ideally, right, and it may be, I won't say more important, but when you're dealing with kind of a very high, like a first degree kind of scenario, getting the NCR and you know, it's maybe immediately apparent to you, right, in speaking with your client that there is some underlying mental health issue, particularly some psychosis that's going on. An early immediate mental health assessment done, or a forensic assessment done, if you can get one done kind of in like the immediate short term, is really helpful. Even better if the forensic psychologist is prepared to videotape it, because you can then have, right, as what is potentially evidence that's then given to other assessors that are going to come down the line 60 days from now, a year from now, when you get the Crown asks for court-ordered assessments, you have that real time. How was the person behaving and responding in the immediate aftermath of what still might be an ongoing psychotic episode? And that can help you to pin was this psychosis active at the time of the incident down? Where that gets a lot more difficult, as Stephanie was just explaining, when you're trying to kind of reconstruct it a year later or more in some of these cases backwards from psychological testing. So it's not always possible. And, there are only so many doctors that do these kinds of assessments, but to the extent that you can get that assessment done, it's important. And I would say it's still important even when you have a recorded police statement, because the police officer is not trained to kind of ask the questions and to elicit information that would cause a person to display the symptoms or provide insight into those kinds of things. Whereas a doctor trained in that methodology is and can better capture that. And you may be in a position at some point where you're kind of juxtaposing what happened in the police interview versus what happened in the interview with the forensic psychologist in terms of the behavior at a moment in time and whether or not someone's actively experiencing symptoms.
So we wanted to actually leave a few minutes at the end to answer questions, but what I think I'm going to do is go down the line and ask if there are any final reflections or parting thoughts on the subject of NCR from each of you, starting with Justice Moore.
It's a life-changing decision for your client or your accused person if you're acting for the Crown. This is not, a 30-day matter. This is not a couple of weeks. This is something that's going to be with them and affecting their liberty for many years to come. And you really have to be very diligent, make sure that you've gone through everything top to bottom, and just give your clients everything that they need so that they can make informed decisions and to defend themselves the best that they can. I mean, like in sentencing, I wish I could give a homeless person a home. If I have mentally ill people, I wish I could make them all better, but I can't. So I think you have to, you may have a bit of that social work inclination in mind when you're dealing with your client, but you've really got to, I think, put their liberty interest and their instructions at the top.
Stephanie?
And I'll just add also that when psychology is involved in CR and NCR assessments, to keep in mind, like this is not a silver bullet. So there's not a direct kind of one-to-one correspondence between the psychological constructs that might get assessed during testing and the legal capacities and the legal test of NCR. That sometimes this is a bit of an uneasy alliance, and that certainly the psych testing results are certainly almost always relevant, but they're not directly informing a legal decision, that those two things conceptually are separate.
Jolene?
Yeah, I would just say on an involuntary NCR verdict, so one that's Crown-led and that you're opposing, it's really important to keep in mind that if, at the end of the day, the client's going to want to appeal the conviction and ultimately get that set aside, right? The involuntary NCR. The criminal code makes it very difficult to set aside the jurisdiction of the ORB. And I'll go so far as to say it's almost impossible with how difficult it is. And so you really, as defense counsel, want to fight that finding of guilt at the outset really, really hard. And kind of create the best framework that you have, because unlike when you're sentenced for another criminal offense, where if you were sentenced for a term in custody, you could get bail pending appeal and your sentence wouldn't be served. And if your appeal is allowed, you may never serve that sentence. When you come under the jurisdiction of the ORB, you will continue under the jurisdiction of the ORB even while you're appealing the conviction and the NCR finding. And that can be a very difficult experience for clients.
Jennifer?
Let's comment on risk assessments, particularly once a person's in the system. So it's important to, if you're reading somebody's annual report, to draw out the details of some situations that might be interpreted as higher risk. I've encountered situations where someone's told they have an aggressive expression on their face when they actually had a headache, and that they were violating rules, which amounted to offering another patient a snack. So often the ORB doesn't understand this. If you don't bring it out, they're not going to understand that. And finally, that statistically, actuarial risk assessments have a fairly low reliability when it comes to being applied to the individual themselves. So if you come across a particularly egregious risk assessment, you might want to get someone to assist you with analyzing the reliability and validity of that scale.
Interesting. Stephanie, do you want to respond to that last one?
So I could take up the whole afternoon and I won't. But yes, certainly, I think having somebody who understands the psychometrics and the research behind these risk assessment tools is essential. And particularly if a risk assessment is being carried through, right, year after year, you know, it's important not just to really understand how that risk estimate was arrived at, but to also understand how it might change over time, and kind of arguing that these change assessments are just as important as the initial estimate itself.
I'll
Okay.
just add to that, something that we've been talking about in different policies at CAMH recently is the need to mention people's strengths as well as their weak points, and seek that out when representing.
Okay, I think we have about 5 minutes left on this panel. I do not have access to questions that may be coming in from to the Zoom. Are there any questions in the room? Yes.
Just a quick question. And I think this is for all of you, but you decide and you judge just as a professor on how do we evolve with respect to NCR from let's say 10, 20 years ago and find cultural competency and and the notion of having making sure that we have the healthcare systems, the social workers, psychiatrists as well coming into these conversations. Have we evolved, or are we still limited to that?
So I'll summarize because I'm not sure without a microphone if they can hear on the Zoom. The question, as I understood it, is whether in the last 10 years or so, we've evolved in NCR, in making NCR assessments, in our cultural competences, and in engaging in a sort of multidisciplinary, complex, nuanced conversation that involves a different expertise and a broad range of relevant expertise. Anyone want to? No, all good. Anyone want to take a stab at an answer?
I can answer it somewhat. Sometimes yes, sometimes no. We spent a long time asking for demographics to be kept on the use of force within the mental health system. And just in the last few years, that was done at the Center for Addiction Mental Health, and it found out that people who are Black were being restrained 3 times the rate of people who are white. So approximately 3 times. So obviously that was not culturally competent. To give CAMH credit though, they did then embark on a whole training program related to anti-Black racism to address that. However, most hospitals don't keep those demographics and therefore don't address all the biases that happen.
I have found too that you can take some steps. So, when the doctor's writing the report, they have a conversation with the client, and it says, everything that you tell me is not privileged and it will end up in this report. But sometimes some of that information for someone who's being very honest, when it comes out and is publicly accessible, can be very damning to them culturally, right? For a collateral reason that's not relevant to the NCR finding. And I've actually, and it took quite a few steps, but the Crown ultimately agreed to redact when the doctor agreed that that information was not relevant to the ultimate conclusion on NCR from the report. And it's really important when you have kind of like that culturally sensitive information that's going to have knock-on consequences for a person in like their life other than this incident, that you get that redacted at the front end. Because once that report gets sent from like the whatever the exhibit copy just goes to the ORB, and then it's the report that just keeps getting shared over and over and over again forever. So if you file the wrong report, then you really get stuck at that front end. So there are some steps that you can take if some of it kind of comes out culturally insensitive on the back end.
Anyone else want to weigh in on the question of whether we've made gains in terms of cultural sensitivity?
I think we have. I mean, I think optimistically, for example, at CAMH, we incorporate the cultural formulation interview as all part of initial assessments. That said, I still think there's a long way to go and always room for improvement in terms of especially incorporating somebody's cultural norms and identity into psych and risk assessments. And you know, it is easier said than done. I think it also necessitates a team, a clinical team that is culturally diverse and goes beyond just kind of professional translation or interpretation services. So I think so too. So I think we have come a long way, but I think there's still a lot of room for improvement.
Yeah, I'm trying to think of an example of how we've progressed. I can't think of any off the top of my head, which is kind of a depressing answer to give you, unfortunately. I am certainly aware with respect to the actuarial tools that many of them are based on mostly populations of white men. So I've had women come before me, and there's really little validity to many of the tools that they're using because they just weren't designed with women in mind, with women as part of the sample population. And I can't think of a case where I've gotten both a Gladue report, for example, or a Morris report along with a 672 assessment. I would think there must be cases out there, but I haven't personally done one.
I think we've made some progress. I mean, we do have recognition by the Court of Appeal for Ontario, at least in the review board context, that part of the board, and maybe the next panel will talk about this, but part of the review board's proper decision-making is to consider, where available, culturally sensitive placements and programming for people who are found NCR. We also have the Supreme Court of Canada decision in, I'm blanking on the name of the case, Anita. What's the name of the case where the Supreme Court said that an actuarial risk assessment tool developed on a population of white men? You were, thank you. That an actuarial tool developed on a population of predominantly white men was basically not appropriate for Correctional Service of Canada to use on an Indigenous inmate to predict risk. And so I would say there are, that's just two examples where we're seeing at least some recognition of the fact that there needs to be greater, especially in a super heterogeneous country like ours, and in this city like ours, there's a recognition that we need to be aware of these things. The law needs to be responsive. The forensic mental health system needs to be responsive. But of course, as Stephanie and others on this panel have said, there's still a long way to go. I think with that, we're done. I want to thank my fellow panelists very much for their interesting and insightful contributions.